Welcome to this 2020 WCA Annual Conference Virtual Workshop. Thank you for participating in our online event. We also want to thank our annual partners and sponsors for their commitment and ongoing support of our 2020 WCA Annual Conference. Please note our virtual workshop presenters will answer questions at the end of their presentation. Be sure to type in your question in the chat or Q&A section at the bottom of your page. If you've called in, simply hit *9 to raise your hand and be unmuted by the host. Again, thank you for your participation in today's WCA Annual Conference Virtual Workshop. We hope you enjoyed the presentation.
This is Implementing Pretrial Justice in Wisconsin. I'm Rhonda Frank-Loron.
And I'm Tiana Glenna.
I'm a graduate of the University of Wisconsin Law School and the Jean Lane Ware Leadership Academy through the Wisconsin State Bar Association. I have extensive experience in criminal justice at the federal, state, and county level. I'm a Certified Pretrial Services Professional with honors in Pretrial Release from the National Association of Pretrial Services Agency, also known as NAPSA. Among my prior roles, I have been an assistant district attorney in Marathon County, a pretrial assessor in Dane County, a United States probation and pretrial officer in the Western District of Wisconsin and the District of Puerto Rico, an investigator at the Office of Lawyer Regulation, and an associate attorney in private practice.
I'm Tiana Glenna. I am the criminal justice director in Eau Claire County, which is in Eau Claire, Wisconsin. I oversee much of the early interventions, diversion programs, and manage the Criminal Justice Collaborating Council in Eau Claire County. I have a master's in vocational rehabilitation with a concentration in counseling. I was certified law enforcement and jail certified, and I am currently sitting on the state CJCC committee and part of the EBDM committee. Thank you.
Thank you. All right, here's the roadmap. The basics of pretrial justice is going to be covered, the legal and evidence-based decision-making, evidence-based decision-making in Wisconsin, which is also referred to as EBDM, pretrial pilot program that Tiana is, her county is participating in, and I'm the pretrial program manager of, and sort of the future, where we're going. What is pretrial? I understand that a number of you may not be familiar with pretrial, other than maybe on TV shows. Pretrial period is the period from initial arrest through case disposition. Many key decisions occur during this phase, including but not limited to the decision for an officer to book a person into jail that they thought was committing a crime, to cite and release, for the district attorney's office to determine to charge or not charge, if a person would be better served in a diversion program, to detain or not detain in a local jail. And then, the judges decide bail and or whether there are reasons for conditions of release. The period prior to case disposition is what we're talking about here. Case disposition means that someone has been found guilty, someone pleaded no contest, someone was found guilty, a guilty verdict from a jury trial, or the case was dismissed or they were acquitted. That's how a case ends. Throughout this phase, the person is presumed innocent. People have not been convicted during this phase, and because they haven't been convicted, they still are entitled to, the presumption of innocence. If a person is arrested and they go in front of a judicial officer, the judicial officer needs to decide, will this person be released? Will this person be detained? If released, what conditions should be added?
And that's where bail comes into play. And this is heard typically at the initial appearance, which is the first time that that person is seen in front of a judge. And this can be one of two ways. In Eau Claire County, we have a lot of what they call order-ins. So a person has contact with law enforcement, charges are brought up for that person, but they are not brought into custody. And they are ordered in. They are given a date to appear in front of the judge, and a bail is set. Those that are brought into custody are seen within a timely period, and typically the next day, with their initial appearance. And at that point is when bail is set. And it can be set in a couple ways. When you hear about bail, it is not typically money. It's money is the end result. Money is the condition of bail, whether it is a signature bond or a cash bond. Some of our clients that come into the jail do have probation holds, and so they may have gotten a signature bond, and which means they're signing that they are going to be coming back to court at a certain time. Same with the cash bond, they have to post a certain amount of money, and that they're promising to come back to court at a certain time. But if either of those cases they have a probation hold, that probation hold may keep them in jail or detained longer. The reason for bail and the release is the presumption that every person should be released. The reason for the detention is typically that the judges are afraid of that this person may not show up for court, the failure to appear, as we'll be referencing it, or the new criminal activity, ensuring that there is public safety when this person is released during that pretrial phase. We will speak to this more in the legal principles that are aligned with pretrial. So this is the focus and the trigger for that pretrial monitoring, what we'll be talking about later as to that release based on the risk.
Yeah, and here at the bail stage, it's just research has shown that these decisions are enormously impactful on the defendants, the community, and the criminal justice system. So we'll move on to the next slide. Legal and evidence-based decision-making. So consistent with guiding legal principles, the goals of a pretrial system is in nearly every state and locality are to maximize public safety and law-abiding behavior, maximize court appearance, as Tiana was saying, and maximize pretrial release and minimize pretrial detention. So pretrial decisions a judicial officer makes, whether to release or detain the person, and with which conditions of release, should strive to achieve these three goals simultaneously. And it's not easy. These goals sometimes compete with one another. That's why judges are asked to balance all three for each case and make the best decision they can with the information they have. For legal-based practices, there are certain legal and constitutional rights afforded to accused persons awaiting trial. For evidence-based practices, it's empirical research, what it tells us to do, what works most effectively to achieve our pretrial goals. The laws tell us what we can do and not do, and the research tells us how to do that effectively. Legal principles, presumption of innocence, we talked about, right to release. Release must be the norm. Two constitutionally valid purposes for limiting pretrial freedom is court appearance and public safety. Detention prior to trial is the carefully limited exception. That's what the Supreme Court said in U.S. v. Salerno. The right to non-excessive bail, so a person should have the least restrictive conditions. A person has a right to due process, right to equal protection, and individualized bail settings. We start this review of these fundamental pretrial legal principles and constitutional rights. Certain legal and constitutional rights are afforded to people awaiting trial. State and federal laws set parameters about who can and cannot be detained and who can be released. The Supreme Court has been unambiguous in stating that in society, liberty is the norm and detention prior to trial is the carefully limited exception. This statement makes clear the strong default presumption that people accused but not yet convicted of crimes must be released while charges are pending. And courts can depart from release only in a relative small number of cases when there is a strong, legally justified reason for doing so. The Supreme Court has also held that there are two constitutionally valid purposes for limiting pretrial freedom, court appearance and public safety. The Eighth Amendment of the U.S. Constitution states that excessive bail shall not be required. All conditions of release, whether financial or otherwise, are subject to this clause. It has been interpreted to mean that the conditions of release must have a reasonable relationship to the identified risk, and this identified risk must be a proper purpose for limiting pretrial freedom. So release conditions must be designed to ensure one or both of the constitutionally valid purposes: court appearance and public safety. These legal principles come into play each and every time a judge makes a decision about releasing or detaining a person pretrial and when setting release conditions.
So what we're going to talk about in this slide is that intentional detaining of a person in the county jail. And the courts have historically held that intentional pretrial detention can only be used when a judicial officer finds that that person poses a very high likelihood of fleeing from prosecution, meaning they're going to abscond, they're going to leave the area, they're not going to come back to court, like we mentioned before, the failure to appears, or they have a very high likelihood of committing violent or another level of a serious crime. That new criminal charges, you're going to be hearing that as we're talking here. So in Wisconsin, like I mentioned earlier, we have a few options. We have the signature bond, or we have the cash bond. And in order for a judge to ensure that, hey, I'm nervous about this person getting out there for the public safety aspect of it, I have to, in order for me to detain that person, they have to look at that higher level of cash bond. And so at this point, that's what we have to be able to hold a person in custody, is through that increased cash bond. And we're going to be talking about the PSA and its focus on that risk factor. And that goes to what I just mentioned about the judicial decision based on those risk categories.
So Wisconsin has a presumption of release, and it's written in our Constitution. It's codified in Section 2 of the Wisconsin Constitution, and I'm going to quote it. All persons before conviction shall be eligible for release under reasonable conditions designed to assure their appearance in court, protect members of the community from serious bodily harm, or prevent the intimidation of witnesses. So Wisconsin has that extra factor about protecting and preventing intimidation of witnesses. That's different than what has been adjudicated in the U.S. Supreme Court. Monetary conditions of release may be imposed at or after initial appearance only upon a finding that there is a reasonable basis to believe that the conditions are necessary to assure appearance in court. So when determining bail in Wisconsin, it's limited to the consideration of likelihood of court appearance and of community risk to serious bodily harm and risk of witness intimidation. Some people have the misimpression that in Wisconsin, signature bonds are the only alternative to cash, and that's not accurate. Wisconsin statutes section 969.03 sub 1 and 969.04 sub 1 allow a court to release a defendant without bail.
So when we look at everything that was just said as to how a person is released, the courts really want to focus on individualized release. We don't want to have the cookie cutter release. Oh, you're charged with X crime, so you're going to be released on X amount or in X means and given a certain prescribed release conditions. So conditions, financial or otherwise, should not be imposed categorically, as I just mentioned, or simply based on that criminal charge. We really have to focus on, as Rhonda mentioned earlier, that least restrictive condition. So what is by the best means that the courts can apply to ensure that person comes back to court and does not commit a new criminal activity during that pretrial period? Money does not always equal public safety. Remember that. So if you are poor and you only have $100 cash bond, you may not be able to pay that $100 bond. But if you are on the other end of the spectrum and have plenty of money and you committed X crime and the judges offer or give you a $10,000 cash bond, you may be able to pay that bond. And so it depends on the ability of that person to be able to release themselves from the custody based on their monetary situation. Overconditioning is another factor that we're going to get into when we look at the PSA. Overconditioning can also be harmful. Putting more requirements on that person during that pretrial phase can allow them to fail or allow them to not embrace those aspects that make them less risky than somebody else. This is where that aspect that we're going to be talking about with the risk conditions, the risk-based supervision, the risk-based monitoring is going to come into place. So we're really able to individualize the supervision and the monitoring pretrial based on that person's history. And again, Rhonda mentioned the 3 M's. We call them the 3 M's: maximize public safety, maximize court appearance, and maximize release. So those are the 3 M's that we're really focusing on when we start talking about the PSA and how we afford the courts more information on that front end to make those better decisions. We talked about the release without bail, we talked about the cash bonds, and we talked about the signature bonds. This is another aspect to provide the judges, the district attorney, the public defender, more information about that person's risk at that time.
You want the next slide, Tiana?
So how did we get to this point? When we talk about pretrial supervision, and this term that we're going to be talking about is the PSA, that screening tool. Well, I'm going to throw out another acronym for you. We got this thing called the EBDM, the evidence-based decision making. Some of you have already heard presentations on this or have read on it, or your county may have been engaged in this. But this is really the foundation as to where we came to the pretrial monitoring aspect of it. So now you understand kind of that aspect of what we were talking about, what bail is, what pretrial is, and the fundamentals of the legal principles, which are well laid out in the document, but can be confusing for the layperson. I mean, we've been working in this for many years, and it's still always an interesting conversation to have as to the different changes and the nuances everybody has to understand in order to be able to work a person's process through this criminal justice system. Mm-hmm. So how did this EBDM thing relate to Wisconsin, and how did it bring us to where we are? And this came from the National Institute of Corrections. If you haven't been on their website, you can go to that website to get more information on this. And that is the kind of the cornerstone for what we use as information, the newest, the most recent research out there. But they initiated this process called evidence-based decision making. And what it is, it's an empirical knowledge and research supported by principles to justice system decisions made at the case, agency, and system level, and seek to equip criminal justice, local and state, we're going to be talking about that connection, policymakers with the information, process, and tools that will result in measurable reductions of pretrial misconduct, post-conviction, reoffending, and other forms of community harm reduction resulting from crime. So when we go to the next slide, when we look at why EBDM, the really smart people out there through NIC, they said, what if we laid out this foundation that said all these great scientific methodologies, measurements, important information that all these researchers have found and have proven to be truthful, and the successes from all these different individual agencies, counties, and piece them together and put that empirical research into a format, what they call the EBDM framework. So they took a few years and did this work with all the really smart people. They put together this framework and said, if you implement this inside of each of these counties, could we bring those earlier concepts I mentioned together so we can use research programming from an agency system-wide approach to better impact the outcomes of not only the system process, but the individual process and experience as they go through the system. So we noticed that there was a lack of system collaboration. We all have our own little silos. The DA has a certain role that they play in the criminal justice system. The public defender has a certain role. The law enforcement, they have a specific role that they have to play in bringing people into the system and controlling crime in the community. So what if all these people got together and said, what is our ultimate goal and how do we all work together and to make better the outcomes and the experiences for all those, not just the clients that we're serving, but the staff that have to work in this field. So what we did is we took, we brought all those people together inside of each of the systems, and we read and reviewed the framework. And then we said, how can we implement this inside of our system? So if we run to the next slide, inside of the framework, there are 4 guiding principles. And when we look at these 4, I'm not going to read them verbatim, but everything we do, especially in Eau Claire County, when we want to enact a new program or looking at what if or why is something happening, why do we have an overcrowded jail, what can we do with that population, how can we divert more people on the front end of the system, we go through these 4 principles and say, how does this process or what is our concern and how does it fit into these? So professional judgment is enhanced when informed by evidence-based knowledge. So you got to take the research to inform what you do. And every interaction with the justice system, this is the huge one where we have the training and the education and the research as to how can we reduce that harm reduction right from the get-go when we talk to somebody on the street. And not only is it with the case manager who's ever working with that person at the end result, but that law enforcement, the judicial officer, the judges, the public defender, the prosecution, every interaction with a person has an opportunity for a harm reduction. You never know when you're going to impact that client that you're working with.
Or their family members.
Exactly. And that's another, victims' rights and victim services. How do we balance those two out? We are so focused on that criminal aspect of it. Sometimes you forget about that victim aspect of it. That's why we have those special trained people in the system to bring that conversation up all the time. Mm-hmm. And when we look at the systems, we have to collaborate. We cannot be stuck in our little silos. When we did our systems map, which I'm going to talk about in the next couple of slides, we did this thing called the systems map, and we brought everybody together. And we learned so much from what law enforcement does, how they process things, to what the jail does, and then from the courts. Sometimes you don't know what each other does, but when you understand that impact from your actions to the reaction of the next person in line or the next process in line. So when we work collaboratively, things can happen. And as we go back through, and we're going to be talking about data, we have to enforce, reinforce, review the data and the outcomes as to whatever we're doing. We cannot assume something is working. We have to have the data to support it. And from that data, you have to be vulnerable enough to make changes inside the system. Telling the DA or the judge they got to change their approach to something is very scary. But if you have the research, you have the support of the CJCC Criminal Justice Council, and you have the data to support it, it's an easier explanation as to why something has to change. Mm-hmm. So when we look at the next slide, so now we're going to dive into when and where this all started. A lot of things had to happen over a number of years. This does not happen overnight. And we're going to go back to 2010. Eight. Well, originally 8. Yeah. Ugh. Yeah. I had to check if it was.
You were so young then.
Yeah. Okay, let's go to the next slide, Rhonda, please. You're in control of this. So here is we call these things phases. By the next slide, you're going to be sick of hearing about these phases. But I originally talked to you about NIC saying, hey, let's take this concept, let's get all these really smart people together. And this is where Rhonda said it did start in 2008. They brought all these people together. They created that framework. And then in 2009, they put out a solicitation to everyone across the nation to say, hey, we have this really great idea. If you guys follow this framework and you dismantle your criminal justice system and you apply these concepts and bring it back together, we may have some better outcomes. And so Eau Claire County at that time, I was hired in my position in 2008, and I was told to look at how we can collaborate more effectively in the criminal justice system. And this was the best opportunity I saw because it had the research, it had the data, it had the experts that could come forward and help the county redesign our approach. And not saying we're doing everything wrong. We were doing a lot of good things, but bring it together in a formatted process that everybody can have some decision as to how we can improve. So that was, we were awarded this opportunity in 2010. And there was the interesting fact of this, there were 6 states, 7 counties, and 2 counties in the state of Wisconsin. I think they did this intentionally because they took us little Eau Claire County and Milwaukee County and said, hey, you guys apply this process and see what happens. And I believe their intention was that it can be applied at any level of system approach. So yep. A small county to a larger county. I'm going to quickly go through the states. So Colorado, Indiana, Minnesota, Oregon, Virginia, and the 2 in Wisconsin. During this process, Milwaukee said pretrial is an area we want to look at. Eau Claire did not until we get into the next few phases. So let's go to the next slide here.
Okay.
So then, yep. So that phase 3 was us. I talked about doing the systems map. So we brought everybody together and said, hey, we're going to go through each decision from the point of law enforcement contact to probation and parole, sentencing, everything else after that. And we picked some change targets. Each state did this. And we finalized that, implemented a lot of work in that. We can go through that at a different time as to what Eau Claire County and some of these other jurisdictions did. What I want to get to is this slide here. So after phase 3, NIC said, hey, I wonder if we can take this to the state level. Remember before we talked about the state and the local collaboration? This is where the state and the local collaboration came together. I mentioned at the intro, which was not as impressive as Rhonda's, so thank God I have her as my co-host here. But I mentioned that I sit on the state CJCC committee. This was formed as part of this process. We also had a statewide EBDM committee that was also formed as part of this process to take these phases through to the next level. So phase 4 was preparation for expansion, getting those committees together, saying what would it look like, what do we want to focus on, doing another systems map at the state level, which was very interesting compared to the local level. Phase 5, this is where we started looking at what the other jurisdictions, offering other jurisdictions to do the same thing Eau Claire and Milwaukee did. And those other jurisdictions were Eau Claire. We were part of that also. Chippewa, Waukesha, Marathon, Rock, Outagamie, and La Crosse. Milwaukee was part of the discussion because they've already implemented pretrial. But when all the counties did their systems map, pretrial came to the forefront and said, hey, we need to do some work on this. So that's where we are today in moving forward with pretrial. And we moved away from the phases because I don't know if the numbers go high enough, but this is where we're at for the implementation of pretrial in the state of Wisconsin. What this also, I forgot to say, what this has also helped is it's a bottom-up approach. So it's not the state dictating what the locals should be doing. It's the locals supporting and informing the state as to what their needs are and being able to have that flow of communication, not just in pretrial, it's a lot of facets, but pretrial has been the focus for this presentation, and which has worked well, because state telling a local that they have to do this can be off-putting sometimes. But when we have that flow of communication, that collaboration, it's has been working really well. Rhonda, you're up.
All right, why pretrial? Well, research has demonstrated that detaining low and moderate risk defendants in jail, even for short periods of time, meaning 2 to 3 days, can increase their risk for misconduct, both short-term and long-term. Releasing high-risk defendants without assessments or supervision can also be a public safety concern. It can go both ways. Defendants detained pretrial are more likely to be convicted and receive longer sentences than defendants who are not detained during the pretrial stage. The likelihood of being sentenced to jail or prison for longer periods of time is more pronounced for low-risk defendants who are detained at pretrial.
This was a huge
yeah.
point for a lot of our stakeholders to understand the research behind that. So if you haven't seen it, I'm sure we'll have the link for you at the end, but it's through Lowencamp.
Yeah, and if anybody needs reference to any of the topics that we've talked about or research we've talked about, please reach out to us, and I'll share with you the links. There's this national movement to address front-end criminal justice system changes. Each local team and the state team identified this, as Tiana had said, as a key decision point in the process. We're emphasizing public safety and the legal rights of the defendant here, in focusing on pretrial. Pretrial sets the stage for everything else in the process. Research, so let me see. So there's a high cost that's associated with pretrial detention. It's like these collateral consequences that a lot of people don't think about. A person could lose a job if they were detained even for just 1 day. Let's say they had been sick, or they really don't have sick leave. Their boss could say, "Oh, you didn't come to work, you don't have a job." And particularly right now, in these tough financial times, that's huge. It's not like there's lots of jobs out there. Say a person was supposed to be having custody of their child during that time that they were detained in jail. They can lose custody of their kid. They can lose access to social services. Say they were receiving mental health treatment, substance abuse treatment. That detention in jail can kind of stop that treatment, and they'd have to reapply and get on the wait list all over again. They can lose their SSDI and SSI while they're in custody in jail, and they have to reapply to get it. So there's always a delay, right? They could lose their housing. They could lose access to educational programs, and it's loss of family and friend contact and support. So those are the collateral consequences. So now we get to the pretrial pilot program. So I'm the pretrial program manager. I started in December on this project, and Tiana and the other site coordinators had been working on this from the ground up. So I'm coming into it a little late in the game.
No, but with a lot of expertise that and the understanding of what this pretrial was. So don't downgrade. But I wanted to emphasize one point that I missed earlier. This EBDM initiative from 2008 until present came with no money. So all those counties did not get a grant to do this. It was at the local level and saying, we want to implement change. Much of what we implemented, I can speak for Eau Claire County, didn't cost money. It cost time and persons. I mean, we were meeting crazy for the 10 years, and it was a lot of time, but there was no money. We were receiving expertise, those experts in the field to come and help guide us through those decision points. And we'll be talking a little bit here on one of these slides that it wasn't until recently that money was infused into these local counties to help support the implementation of this work. So with the pretrial pilot program, Rhonda talked about the locals saying, okay, we want to do this, so let's do it right in Wisconsin. And we have some nuances. We talked about the preventative detention, which we don't utilize that much. We talked about the cash bond, the signature bond, the probation holds. We do not have bail bondsmen in Wisconsin, which is great. And that has helped us immensely in the work that we're doing.
But by not having bail bondsmen, if cash bond is $100, a person has to post $100.
Exactly.
And,
yes.
and in states where there's cash bond, bail bondsman, the person only pays 10%.
Yep.
So if someone comes from another state that has bail bondsman, they're like, oh, well, that's just $10. And you're like, nope, it's 100.
Yeah. Yep. But it's still, there's research and discussions out there about the pros and cons. So that's for another presentation. We were supported by the NIC with the framework for pretrial justice essential elements of pretrial system. This is another golden Bible as to pretrial, and it is what we worked off of in implementing the pretrial pilot project. There's the NIC measuring what matters. That's the data. Remember number 4 on the guiding principles. This is how we're measuring what we're doing. And then there's NAPSA, National Association of Pretrial Services Agency, the standard pretrial release documents. And these were all the documents that helped guide us set the framework for implementing pretrial in the state of Wisconsin.
And I just want to do a little plug right now for the essential elements. Wisconsin has been one of the states that has been picked for essential elements training by NIC. And so hopefully we'll be able to orchestrate that before the end of March, because that's when the grant runs out. We wanted to do it in person. We kept putting it off, but with COVID, I think we just need to do it online like this. So we're working on it. Stay tuned. So I think we can go on to the next slide, don't you, Tiana?
Yeah,
okay.
Yep.
All right, the pretrial pilot program mission. Develop and implement policies and operational procedures which follow legal and evidence-based practices in pretrial release and detention to support the goals of, and I wish we were in a crowd, I'd have you all cheer it on, maximize public safety, maximize court appearance, and maximize release, the 3 M's.
We should have 3 M&Ms on the bottom.
I know.
That's how I remember it.
I
know.
Let me see. The pretrial pilot seeks to test a set of legal and evidence-based practices consistently. That's very key here. We want to be consistent while at the same time recognizing that there are variations in local practices and resources. We want to have the consistent use of pretrial risk assessment tool, the public safety assessment, also referred to as PSA, consistent data definitions and capture, and consistent supervision practices. And we're going to learn from the analysis of this data and modify our approaches. It's not once it's all implemented this way, it's in stone, we're not going to move from it. The whole idea is if the evidence shows do something different, we do something different.
Yeah, definitely. And so when we go into what is pretrial success, so we mentioned it before, they are not committing new criminal crime activities during that pretrial stage, and they're showing back up for court. We want to ensure that they are released from custody when safely we're able to do that based on their risk. We have some people that just shouldn't be based on their charges or their risk to themselves or the risk to others in the community. We want to monitor that We want to monitor that success and ensure that we're collecting the right data and that we're serving them at the pretrial stage where we need to in whatever manner that may be with court reminders. Which is one of the biggest things that we can do in a county justice system is just calling a person. I missed an appointment for my son the other day because I did not receive the call. I forgot about it. But when you receive the call for your hair appointment or your dentist, you're like, oh, thank you for that. So that's the same principle with court appearances. So
well, and especially now because court appearances are changing because of COVID.
Yep, exactly. It's a new world. Again, working that measurements and that reporting out based on the measuring what matters.
So what's failure?
The opposite. They are either continuing to be detained in jail unnecessarily. That's where some counties have implemented the look back. So if a person is sitting on a cash bond, they'll go back in a week or X amount of time and say, hey, why is this person still here? Many times they review it and they're like, okay, this person XYZ happened, or there's something inside their case that we need to detain them. They have had previous failure to appears before, and now we've given them enough opportunities to be successful pretrial, and we just can't anymore for the safety of the community. And the other failures are they don't show back up for court, or they do have a new criminal charge once they're out on pretrial.
All right. Well, what is risk? In context of pretrial, risk is connected to a person's likelihood during that pretrial period of not appearing for court and being arrested on new criminal charges. This is different, very different from post-conviction notions of risk and those risk assessments. We're not talking about recidivism here. This
We're not
come to court,
talking about,
don't get arrested for new charges.
yeah. And one other misconceived notion of pretrial is that we're going to implement and provide all this treatment and services for the person pretrial. We remember when I talked about least restrictive conditions, we have no authority to tell a person you need to go to AODA treatment, you need to go to XYZ treatment. That is pretrial. They are to be released. You're innocent until proven guilty. All that comes after. So this risk tool is not focusing on the criminogenic factors of that person. It's just return to court and no new criminal activities.
That's right. So the public safety assessment, the PSA, it's an actuarial pretrial risk assessment tool. It uses research-based factors to predict pretrial success or failure. These factors are characteristics such as a prior conviction that when present indicate an increased likelihood of pretrial failure. Pretrial assessments result along with other information. The pretrial results along with other information can help inform pretrial decisions. So you've got this report, but you have the prosecutor and you have defense attorney that also know additional information about a person, and that's they can present and argue if they think an appropriate condition like no contact with someone or what have you. So we talked about the only two constitutionally valid purposes for limiting pretrial freedom are court appearance and public safety. An actuarial pretrial risk assessment is an objective, statistically based resource that uses pretrial risk factors to assess a person's likelihood of pretrial success or failure. It provides judges and decision makers with additional information to help them make pretrial decisions. An assessment does not take away a judge's discretion. It provides the judge with more information to help them make a decision. The PSA is not intended to drive the decision, but rather to inform.
So we talked about this PSA thing and why should we even believe it? What is this tool? It's another thing that you're going to throw into the mix of everything. And now you're going to have me look at another piece of paper that says, oh, you need to do X, Y, and Z. Well, yes and no. What it is it was developed by the, in 2013 by the Arnold Ventures, which was formerly known as John and Laura Arnold Foundation. And it is, PS uses statistically driven pretrial factors. What does that mean? They had a lot of really smart people that said these are the elements that predict failure pretrial, and they streamlined it enough for us where they used, as stated on the PowerPoint here, 750,000 cases across 7 states court systems. They're listed there, and they researched the data and they pulled all those static questions out and created this online tool that is now publicly available. So you can go on Arnold Ventures, look at everything. It has everything that we've talked about, how it's used, how it's scored, all the behind the scenes information on it. The nice thing about it for us at the local, we don't have to do that initial interview. It's based on static information, which means my assessor right now this morning is entering all the PSA scores into the calculations into the system and popping out some reports for our judges. So it's very it's very streamlined in the interviews, and that information comes afterwards. So Rhonda mentioned in the first slides some of the other factors, the criminal history and the community ties. So I think given the time, we should probably just move on, but just know that there's no interviews, it's public, and all the algorithms are online, and it's continually updated by the researchers.
All right, what makes the PSA unique? Well, Arnold Ventures sought to develop a pretrial assessment tool that would predict the likelihood of failure to appear and new criminal arrests separately. Predict the likelihood of new violent criminal arrests, assess factors that did not depend on interviews, as Tiana had said, improve overall predictive accuracy, be applicable anywhere in the US, and be without cost. The results of this research, created the PSA. So there have recently been some national pretrial groups that are starting to have some discussions about the use of these risk assessments in light of equity concerns. I want to be clear that NAPSA and NIC and many, many groups still support the public safety assessments, and we still support it. So if you have questions related to this tool and the different responses, you can reach out to me and I'll share, there's a number of articles supporting this. So there's some concern that this risk assessment tool can lead to issues of disparity. But the alternative of not having a tool, we're not alleviating. It hasn't worked.
It hasn't worked in the past. So adding this factor just gives more information to all parties. It's not you have to abide by this. It's just more information to better guide those informed decisions at the earlier stages.
Right. So the goal is to utilize the tool to demonstrate fewer differences, that it's neutral, race, ethnicity, gender, socioeconomic status. The use of the static factors, as Tiana had said, it's an improvement. It removes those factors such as where a person lives. But, they are still impacted by some of the systemic factors. So basically, research continues, and research will always continue. And stay tuned. We of course will share when we do our validation, what that research says, but that's off in the distant future. Let's move on to what a PSA looks like.
So here's an example that we have in our county. Many of us through this pilot project have looked at the format that you see in front of you and want to have consistency. That's been the process of this whole pretrial pilot project, is to have consistency across the counties as much as we can. So this is the form you're going to see. It has all the information, the person's information on top, the arrest summary, what they're currently being charged with, the severity on the far right, the actual charge on the left. Now, these are the questions, the 9 questions that are the static questions that you're going to see on the left side of the screen. I'm not going to go through each of them. I didn't even know if you can see this, how big it is on the screen or not, but these are all based on criminal history. It then identifies the failure to appear, the new criminal activity, and then there's a flag. There's a new violent criminal activity. This person is likely to violate violently or commit a new crime in the violent manner. It's not as predictive, but it is still there based on their current charge. On the far right, they're going to show the level. We have 4 levels with the PSA, and these levels are just suggestions as to what should be monitored at each of those levels. The data that we have been seeing so far is Eau Claire County, high percentage of 1, a high percentage of the 4s. So that's the 2 main factors. We have a lot of mandatory arrests that are coming in that are flagging in that low level. And then we have some other significant charges that are flagging in that level 4. The one thing I really want to call your attention to, which you're not going to, maybe you will see, but I can see it because I have a really nice copy. The new criminal activity on the top line. So when you look at this, new criminal activity 1, 90% of that population, based on the 750,000 people, 90% did not have a new criminal activity pretrial. That's their success percentage. So they were successful in 90% of the time. Number 6, 45% of the time. So 45% of the time of all the people that categorized there were successful and did not have a new criminal activity, criminal charge. Same on the far left when you look at the FTA, failure to appear. On the one, 90% again were successful. They came back to court, which is something you wouldn't even think that they would come back to court because you're being charged with a criminal crime, but most of them do. Number 6s are 60%. 60% of the time, those people come back to court. So what's the whole purpose of the PSA? Well, it is to ensure and continue that insurance of those clients and the courts that that person is able to come back to court. And we're going to do as much as we can to mitigate their criminal activity during that pretrial phase. So that's what I wanted to talk about on that page.
All right. Well, Tiana, did you know that most pretrial defendants present low to moderate risk of pretrial failure?
Did I not just say that?
Yeah. Majority of defendants show up to court and are not arrested during pretrial period. And based on the risk principle, we should match the supervision levels with the person's risk. Poor matching of supervision levels, risk levels can lead to increased failure rates. And can you explain that a little bit, what that would mean, a mismatch of that?
Well, just kind of what I said before, when we have somebody that's on the 1 level. So these are people that did something they shouldn't have done. And their tendencies allegedly did something they shouldn't have done. But their tendencies, they have a job, they have a family, they have all the pro-social skills that are allotted to them in the community that will make them low risk. And if you start infusing jail, like we talked about before with Lone Camp, or you start infusing conditions, you need to report every single day for UABA testing. You need to report every other day for case management. You need to go to AODA treatment. Those are starting to pull away at all those factors that make that person low risk. So I'd rather put my resources into those higher risk people where I'm going to monitor them more, because with that low risk, you may have 10% out of that 100% that come back into the system. But I don't want to infuse all my resources, pretrial monitoring resources or other resources, in that 100%, that 90% that will come back, or that will not come back. But we'll catch those other ones at that later end. So it really goes to looking at where do you want to put your resources, and those that are more higher risk, what can we do? One of the best things that any county can do is court reminders. Just give that person a call and say, hey, remember to get here for court on this day. Many of us forget things, like I just did with my child's.
Well, even just the text reminders are great, but if you're able to also have that personal touch and somebody call and talk to a human and say, hey,
how you doing?
Because
okay?
that's helpful.
Anything I can do to help you.
All right, we're moving on to the future. So the future, I love this slide. We need to do more data collection. We're in the process of collecting data from the pilot sites right now, but it's a long process. And our counties are collecting data in different case management systems. So we're still working on all of that. And we need some additional time to complete our performance and outcomes measures document, because measuring what matters, that Bible from the NIC about these pretrial measurements is being revised right now, and a new version hopefully will be released by the end of the year. We need to do local validation. We're starting to make inroads into that. And when I say support, I mean, these pilot sites are also going to help support pretrial reforms in additional Wisconsin counties. And I guess I feel like I should have started this off with talking about how Wisconsin doesn't have a statewide pretrial agency. It's not like the Department of Correction and we've got people everywhere. Each county is responsible for their own pretrial agency or not, and many counties don't have any kind of formalized pretrial agency or system, but are interested. And so we're trying to plant the seeds and grow the plants and see how the fruits are and move it to additional counties. And hopefully we'll have a process in place next year on how to do it. Let me see. Did we want to add anything more on this screen, Tiana?
I don't think so.
I don't think so.
No.
PSA validation. So, the PSA was originally developed and then they went back after it had been in place, right? And then
we
so
looked at the data, and just like we just talked about, you're always improving the tool that you have based on the data and new information coming forward. So we're always working with and looking at the Arnold Foundation as to what other factors or processes do we have to change to continue to improve that. But that also goes to what Rhonda was talking about, the future, where we have to validate it locally because we have nuances. How do we process cases in Wisconsin is different than what Kentucky does. So how do we how do those compare out?
Pretrial pilot program, along with implementing the public safety assessment, pretrial pilot counties are helping create tools and processes, we talked about this, that can be replicated in other Wisconsin counties. The pretrial pilot counties have generated guiding documents to assist other counties implement the PSA and to ensure that it is implemented the same way. We're very far in the revisions of these documents, and when they're completed and ultimately approved by the statewide CJCC committee, these documents will be published on the Wisconsin DOJ's website.
Yeah. And that kind of goes to the next slide as to that's why we're doing this. We've come across many obstacles, many clarifications inside the local jurisdictions. Our struggles are going to be your success. So we're able to go through some of the hard discussions with our district attorneys, public defenders. And then when this implements and rolls out to the other counties, we're able to be there as support for your counties and how do you implement this locally.
Yep. Just a quick, brief legislative update. Criminal justice reforms, including pretrial reform related legislation, previously were proposed here in Wisconsin. However, the constitutional amendment related to bail reform failed to pass. That amendment, though, it would have led to an increased use of cash bail, which is contrary to bail reform efforts nationwide. The Assembly and State Senate are scheduled to reconvene in January 2021, and I don't know what the plans are for any additional pretrial efforts at this time. Hopefully there will be some.
So I guess that is what we wanted to talk to you about. We went really fast, probably not fast enough given the time, but just a basic recap of what pretrial justice is, because for some counties this is very new. And weren't we already doing this? Isn't that part of our process that we've been doing? Well, it's a different focus, a different look. The nuances of legal and evidence-based decision-making is a robust set of knowledge that's out there, and how do you apply it locally? The EBDM initiative in Wisconsin is not going anywhere. It's continuing, if not growing, as to the programs, the focus inside of each of these jurisdictions. The pretrial pilot project, we talked about that. We're in, many of the counties are implementing, many of them are soon to be implementing. So we hope to have some more data and some results off of that in future, continuing to review, recap, and improve. We want to make Wisconsin a success, not only locally, but at the state level, and really focusing on the clients that we're serving and addressing their needs effectively at all decision points.
Mm-hmm. Here are additional resources. We kind of peppered all these different groups throughout this presentation. The NIC, NAPSA, APPR, Arnold Ventures, and a thought I had is, I'm a big reader. If you like Malcolm Gladwell, he has a book called Talking to Strangers, What We Should Know About People and What We Don't Know. He's got a few chapters in that book that actually covers criminal justice and pretrial interactions. And I found it interesting. It's a nice read. So thank you. Thank you all
Thank you, guys.
for being here.
Good morning, all. We are going to jump right into questions here. We're respectful of everyone's time today. As a reminder, this presentation, along with the actual recording of this webinar, will be available on our homepage, WI Counties, afterward. I know that we will share contact information as well with our speakers if people do have additional questions. That did come in as a question, so thank you for that. Let's jump right in. First question, you haven't addressed the racial disparity in pretrial detentions. In the North, we see Native Americans being held at rates that are significantly disproportionate to our overall population numbers. Can you address this issue?
Well, this is Rhonda. The public safety assessment is the tool that we are piloting to try to reduce the disparate detention of minorities. I don't know what county you're in, but it's possible that your county is already considering using the public safety assessment tool. You know, different counties kind of have different populations that are disparately impacted with pretrial detention, like Dane County and Milwaukee County have a lot of African Americans that are detained when you compare it to the overall general population. So if you want to reach out to me more, if you're you know, in the criminal justice system in your county, I think that, Michelle, will my information be shared with participants?
Yes.
Yeah.
Yep. It will be right on the homepage at WI Counties.
Okay. So we can talk more about that if you would like.
Our next question, how can we still use this tool and help with equality? How can it be improved?
Tiana, do you want to answer that one?
Well, I think the whole process that we talked about with the EBDM initiative, with the work that the sites are doing, is working on equality. If you read the EBDM initiative, it is focusing on the individual and ensuring that we are not over conditioning, placing a person in custody based on a signature bond or a cash bond or other holds just based on their specific charge. It is looking at the whole person, and that's where the review comes into place, and that's where the buy-in from each of the county members comes into place. And many of the equalities, you know, they happen at the county level, they happen at the arrest level, but they also happen in the community. So it's bringing that whole focus together and talking as a group and as a system of what are the concerns and what can you do legally within your boundaries that can relieve that impact.
Our next question, how many courts in Wisconsin used EBDM?
Well, you know, formally, Wisconsin, there's 8 counties that we mentioned earlier, and those are the pretrial pilot sites. And those were formally guided by the EBDM principles through NIC, through guided technical assistance. Informally, I'm sure there's a lot more out there. The EBDM information is out there on the website. You can utilize it. They have toolkits, they have starter kits, they have the information. I know my county and the other jurisdictions have gone out to other localities and informed them, talked about them, what we do, what our process is. But formally, those 8 counties that are included in the pretrial pilot project.
And I would say that there's not a week that goes by that I'm not contacted by a county considering doing the systems mapping. So clearly additional counties are moving forward towards implementing EBDM.
Okay, next question. When do you expect to have measurements of outcomes?
Well, there are 2 different documents that are being worked on right now. The National Institute of Corrections is revising their Measuring What Matters document, and They are anticipating that that revised version will be available by the end of this year. Our outcome and performance measures document will not be completed until after we compare our measurements with the revised Measuring What Matters document. So ours probably won't be released until, January or February, because we need to look at the new document and compare and see if we need to make any changes.
But that's just the questions and the measurements as to what we're going to be collecting. Many of the jurisdictions just recently started launching the PSA. So we won't have actual data for at least a year, because we want to ensure that the data that's being collected is accurate and we are all collecting in the same fashion, and then being able to analyze that data. So at least another year before, from the point that the measurements are secured and finalized, and then we start collecting that data.
Our next question, it appears you really need your judges' buy-in to implement EBDM. So what can supervisors do in this regard?
You do. You need your judges' buy-in. You also need all the other stakeholder buy-in. What you can do is ensure that you have a formal CJCC established within your county and give them some authority and allowing them to make those decisions, bringing people together. Ensure that you have a full-time staffer that is leading that. It cannot just be placed on a judge to lead that discussion. And what helped us in Eau Claire County was really following that framework and the EBDM framework and bringing all the stakeholders together and doing that systems map, because that brought us all together, understanding the talking points and being able to move that forward. So I would say, yes, you have to have the judges, but you also have to have the district attorney, the public defender on board, and all the other line staff that go into that work. But having that formal process in place and that oversight committee that can help bring that discussion forward.
Your next question, could the same EBDM process be used to generate best practices for reentry programs?
It has been informing the work that we do in Eau Claire County. So yes, it's not, the EBDM is not just focused on one decision point. It's the entire scope of the criminal justice system, from the point of arrest, charging decisions, sentencing practices, and programs in the jail, alternatives, diversions. That has informed. It doesn't give, you need to do this. It's a decision and a discussion that's born out of that council, that group that looks at each of those decision points and says, where's our bottlenecks inside of the systems? What are some of the areas, the goals that we want to focus on, and how can we apply those goals to our county? Can we even do it? Do we have the resources to do that? And then that's where you look at the system and say, how can we better the client's outcomes throughout the system? So yes, EBDM definitely does inform that.
And to sort of piggyback off of that, Tiana was on the committee where they were identifying all these different change points, these opportunities to work collaboratively and make changes. The pretrial pilot is the result, because that was one of the change points that everyone had identified as wanting to be a focus. So yes, this does apply to all aspects of the criminal justice process and system.
Next question, is there a role for certified peer specialists in the support of individuals during the pretrial period?
Yes, I think there is a role inside of that. How does a county and how is a county able to enact that in the pretrial phase? Again, we can't force people to complete something. So if your county has the resources to a peer specialist in the pretrial phase where they can make that connection, yeah, that would be great. Not all counties have that ability to do that. But again, we cannot force a person to even meet with that person. But it can be an option, especially if they are failing at those higher levels. If you have a 3 and a 4 and they start failing or not returning calls, not showing up to court, how can you work with them to, and what resources do you have to be able to do that and to help them navigate the system on the outside?
Can you describe an example of specific change in the decision process that resulted from data collected?
Well, again, we're focusing on pretrial for this presentation. I don't know if we want to take time. I can talk about what other factors that data led to all the other work that these counties did, especially my county. In the data, we looked at diversion, pre-charge diversion programs, enhancing our DAGP program, establishing an OWI, early intervention program. This is all based on the data. Establishing a co-responder, I'm sorry, not a co-responder, a jail transitions worker that's in the jail to help with the mental health aspect. But when you're talking about the data aspect of it, that is part of the whole process that each of the jurisdictions went through, and we collected a year plus of baseline data as to the number of charges, cash bonds that were in the jail. And that's the reason we came to the pretrial decision.
Okay, our next question here. I wonder if the EBDM approach would also be a useful approach to release, and recently as well as treatment and services offered while incarcerated.
I think I commented on that. If not, I can respond further to that person.
Okay. Yeah, and this presentation is pre-trial. So yeah.
Are certified peer specialists a possible resource for supportive individuals during the pretrial process?
I think, again, I just responded to that question.
Yeah, we got that one.
Alrighty. That is all the questions we have. If there is nothing else, we thank both of our speakers today for their time. Tiana Glenna and Rhonda Frank-Loron, thank you so much. A copy of today's presentation with the PDF will be available at wicounties.org. We encourage all of you to be back here next week for our next 2020 WCA Annual Conference virtual workshop on large livestock sighting. Where do we go from here? You can find that, sign up for that on wicounties.org as well. Thank you all for your time today. We appreciate it.
Thank you. Goodbye.